Good afternoon, everybody. Welcome. Give it a few seconds here to let everybody come aboard. So we'll go quiet here just for about 20 seconds. Well, hello, everyone. Thank you for joining us today. My name is Scott Sauerbeer. I'm the Vice President of Business Development at Ally. By now, you've all had a taste of fall in your area, we hope, as we move into the last quarter of the year. By the way, this time of year is a great time to reflect on this year's performance of your registry and look in the rearview mirror to see how you did regarding compliance-related responsibilities. Today, we'll cover a host of topics such as the new 1099-K and what it means to your registry, tips for running a dual model business, proper caregiver classification and documentation, and some of the most recent legislative updates. Ally will continue to host these types of webinars with Angelo and Polsinelli into 2023. Remember, Ally is the only software designed to meet the compliance standards and daily rigors of running your registry. You are welcome to contact me or any one of our team members for a customized live demo of our platform. 2023 is fast approaching, so if you don't have a solution or a plan in place, we encourage you to contact us immediately after today's webinar. Should you have any questions during the event, please type them into the Q&A. There will be a link at the bottom of your screen. We will address those near the end of today's event. There will be a recording of this event shared with all of you in the next day or two. With that being said, it's my pleasure to introduce you to Angelo Spinola of Polsinelli.
Thanks so much, Scott. I appreciate it. We have a lot to cover, so we're going to jump right in. I am a shareholder at Polsinelli. I'm in the Atlanta office. I do lots of home-based care, both on the consumer-directed side and the W-2 agency side. And Scott has given me a tall task of covering all of these things. He mentioned them, so I'm not going to repeat them so that I can tell you about them, tell you what's going on. So we're going to jump right in, starting with what is the difference between an agency-directed model and a consumer-directed model. And by consumer-directed model, we mean registries, virtual marketplaces, right? In some cases, the state programs like CDPAP in New York, right? And the Minnesota program. Generally speaking, when you're talking about an agency-directed program, we're talking about agencies who are supervising and handling the care on behalf of the clients, right? And supervising the caregivers, setting up the plan of care, right? Handling the scheduling, making sure that they're doing the training, any hiring and firing, right? And managing the care on behalf of the consumer. Those models are typically a little higher in cost because to the consumer because of the additional bells and whistles, the labor costs. They're W-2 models, right? So there are benefits and labor costs that you don't have necessarily under a consumer-directed or independent contractor model. Independent contractor meaning that the caregiver is a independent contractor to the sourcing agency, whether that's a registry or the virtual marketplace or whatever it is. And in those models, now we have caregivers who are really responsible for providing the care, and the caregiver and the client are the ones that are working directly together to determine what the service needs are, what the hours are, what the schedule is going to look like. The agency in this instance is not training, supervising, or influencing the client-caregiver relationship. That's between them. The consumer-directed model, whatever that third-party entity is the liaison to introduce the caregiver and the client. The liaison to vet the caregiver to make sure that the caregiver is qualified by whatever state regulations or requirements exist to service the client, or whatever standard, objective standard that the third-party agency determines, to the extent that there isn't a state requirement. Normally, the consumer-directed model is picked partially for the price point. It's typically a lower price point than what the agency model is, and for the client to direct his or her own care. We're seeing more and more Medicaid providers willing to work with independent contractor models because of some of the rate compression, but that really does depend on each individual state. So what are we talking about today? What I want to talk about a little bit is the standards that apply. And I should have mentioned that not legal advice today, okay? Overview, there's a disclaimer in here somewhere towards the back. I don't know if we're going to get to it. We have so much to cover, so I'm going to be moving quickly. And as Scott mentioned, please do use the chat feature so that we can, or the Q&A, so that we can answer your questions at the end. But what you should understand is that there are a variety of independent contractor tests. There's a ton of them depending on what state are you in? Is it federal law versus state law? What is the issue that's being addressed? Is it unemployment? Is it overtime under the FLSA? Is it IRS taxes? Is it workers' compensation? Is it benefits? There are hundreds of independent contractor tests depending on these issues. So it's very, very important that you understand your jurisdiction. That we hear all the time, like our Florida registries are always saying, well, look, it has to be an independent contractor model. That's what ACA tells us, right? That's the requirement, that to be a registry, we've got to utilize independent contractors. So how could we have a problem with the Department of Labor or the IRS if the state is requiring us to utilize independent contractors? The reason that becomes an issue is because you've got a different standard. And so what the Department of Labor will say is, well, that may be true for purposes of healthcare regulatory law in the state of Florida, but that same worker does not qualify as an independent contractor under the economic realities test when we apply it to your model, right? Different test, stricter test, harder test. Little added bonus for you, the economic realities test that I mentioned is one of the tougher ones to satisfy. The one being tougher than that is something called an ABC test, which applies at certain states. That's something the federal government is trying to put into play at a federal level. That's probably not going to happen. But the ABC test, which you see in Massachusetts and California, that's the hardest, and probably the Fair Labor Standards Act and Economic Realities Test is next. We're going to be looking at that. But first, let's start with tax implications and talk a little bit through some of the issues that Scott raised around 1099s and misclassification for tax purposes, right? And as you can see, just what we looked at before, all the different elements, right? There are penalties that can apply, like the failure to pay overtime if somebody's misclassified as an independent contractor, right? There's going to be a cost, back wages, and penalties associated with that. With taxation, this is a quick, summary of how much that can add up and how much that can add up, particularly when you're dealing with multiple workers. You're not paying people $90,000 as independent contractors in a personal care setting, but you get the drift here. It adds up a lot. And when you're looking at entities like the IRS and the Department of Labor, they are normally looking at the entire workforce, right? They're going to look at the entire workforce. So you are going to have what would be the equivalent of a class action, right? When you've got the Department of Labor or the IRS, and there's no way to prevent that, or the state equivalent of the IRS, right? Or the DOL. There's no way to prevent that because they have the authority to look at everyone within the organization. So we talk a lot about arbitration agreements with class action waivers. Very, very important thing. We're going to talk about that in a little bit. But that isn't going to prevent the IRS or the Department of Labor from coming in and looking at you at an enterprise level. So let's jump into IRS. And what I want to talk about first is the 20-factor test, and really just demonstrate how subjective the 20-factor test is. You've heard about that before, right? The general gist of the 20-factor test is, does the organization have the ability or right to control the individual that's in question, right? And the worker. Is it an independent contractor or an employee? We're going to look at these 20 factors, and the more control there is, the more likely that the subjective test is going to come out as an employee versus a contractor. This is a balancing test, meaning that you don't have to satisfy all 20 factors, but that's what makes it subjective, right? It's going to be in the eye of the beholder, where they're going to look at these kind of issues. How are we paying? Are we paying by the hour or by the project? How flexible is the work schedule? I want to touch on a few of these. We're not going to go through all 20 factors, but I want to hit some of the most significant ones as it pertains to the home care industry. And then we're going to talk about some safe harbors that I think are extraordinarily important when you're looking at federal potential tax liability. So what is the level of instruction? How much does the company actually direct how the work's going to be done, when it's going to be done, what's happening, with the company telling the caregiver what to do and how to do it, right? For example, is there a dress code, things like that, where we're telling them, the caregiver, how to do their job? How much training is there? Is the registry or consumer directed model actually training caregivers on how to do the job? Business integration is a difficult one, right? Those whose services are integrated into the business operations or significantly affect business success are likely to be considered employees. That business integration is similar to the B of the ABC test that I was talking about. That's so challenging, which is the question of how integral is the worker to the business, right? And it's very difficult to say that caregivers are not integral to the business of a registry if without the caregivers, the registry doesn't have a business, right? That's the big issue, and the argument is, and remember that's just one of the 20 factors, is that the registry or the consumer directed model, that agency is in the business of connecting people, but not in the business of care, right? We're not providing the care as an organization. The caregivers are. What we're doing is we're matchmaking, we're serving as a liaison. That's really important across all of these tests, and we'll talk about some ways in which that sort of manifests itself in these investigations when we get into the tips, compliance tips for you. Okay, continuity of the relationship, meaning how long is the relationship, right? Do we have independent contractors that have been working with us for 4, 5, 6 years? Generally that rule of thumb is about a year. After a year, becomes indicia of employment. It's an interesting model here where a lot of times there'll be somebody that you're associated with, a caregiver who picks something up, a client that you have a connection with, and is placed with that client or accepts that client, then goes away for a little while and works somewhere else and comes back. That's helpful. The fact that caregivers work for multiple registries or have other jobs, right? We'll see that trend. That's helpful when it's not a continuous relationship. But the length of the relationship also matters. How flexible the schedule is, that's generally one that is beneficial and favorable for the consumer directed model, because it is the caregiver that is making the determination as to whether they're going to work for a particular client. At least it should be. Now, where flexibility of schedule really comes into play and becomes a problem is if a registry or independent contractor model is staffing a facility as opposed to an individual in their individual home. That makes a significant difference as to whether somebody's an independent contractor or not. So you got to be really careful about staffing facilities, whether that's a hospital, long-term care facility, right? When the work is regulated, and so, okay, we're going to staff you with independent contractors that work 9 to 5 at your facility. That's a real problem for this model. How much work is there? The more work there is, the more likely that individual is to be an employee. That's why independent contractors have a harder time when you're talking about live-in or extended shift services, and there's 60, 70, 80 service hours in a week. right? There's more, full-time control, independence, right, on one organization or one client, more likely than that's a employment relationship, particularly if that's a long-term client. Realization of profit or loss is a really, really big one, particularly given the compressed rates that these individuals are paid and the low rates that they're paid. The caregiver, so often the IRS will look at that and say, yeah, the caregiver really is not controlling their profit and loss because they're not always setting their rate or determining their rate. Maybe the market is, maybe the organization is, but that's what the IRS would be looking for. Working for multiple companies, the more work that's spread around across different entities that are not associated entities, the better it is for an independent contractor model. The caregiver actually putting their business out, advertising for themselves, trying to get work for themselves, that's very helpful. Caregivers who have business cards, who have websites, very, very helpful. That can be challenging in this industry because the concept is of a consumer-directed model is we're going to market for you, right? We're going to put you out there and help you to find these clients that you're not finding for yourself. So that's generally an issue that does not favor the consumer-directed model. The advertising piece, and we're going to talk about the safe harbors in a minute that I think are so important when you're looking at the IRS issues. But let me just cover for a minute, and I want to preface this with, I am not a tax lawyer. That's not me. And my tax lawyer that knows this stuff so well is in the middle of tax season, so we couldn't get him on, but we've got a team here that really address the 1099 issues and the tax implications. So I just want to cover, the basics here, all right, of kind of what's happening, what you do with a 1099, because they come up all the time, right? And if you have contractors should be receiving 1099s rather than W-2s. One of the biggest indicators, as we'll see in a minute, of misclassification is if you have W-2 employees and 1099 employees, or excuse me, 1099 contractors doing the same kind of work for the same organization, right? That's probably one of the biggest indicators that those 1099 workers are not really independent contractors. If you've got W-2s that are doing the same thing in the same company, that creates a lot of issues for the model. So you're picking one or the other. You can have a dual model where you've got separate companies that do separate things, but when it comes to the same organization, it really should be either a contractor model or a W-2 model. Contractors are not appropriate for temporary work. That's a temporary employee, right? So meaning you're a W-2 model, but we've got this contingent staff, we're going to just make them 1099s. No, that's a temporary employee, right? They can be subject to different rules, have a different agreement with them, but they're still employees even though they're temporary. So hopefully that is all making sense. Okay, so with 1099s, there's a 1099 NEC, there's a 1099 miscellaneous, and there's a 1099K. And then you've got federal and state laws that can apply here to tax issues. So the big takeaway is make sure as you are working through your tax issues that you get advice, make sure that you've got advice and understand what the tax laws are in your jurisdiction. But let's just cover the basics here on 1099 and when a 1099 should be issued. They go to independent contractors, right, who are performing services for the payee, right? Who is the beneficiary of the services? Who's actually paying? Not the processor, that's a different issue, but who is paying, right? Is the client the one that's receiving the services, right? Not the registry, but the client is receiving the services. That creates issues for a registry because an individual client in a home care world isn't going to be issuing 1099. So sometimes the registry will step in on behalf of the individual client and issue a 1099 to the caregiver on behalf of that client. But also understand that the services that are performed should be for a business purpose rather than personal, right? And typically the client is not running a business, right? So this gets a little bit complicated as to when you issue a 1099, who issues the 1099, what type of 1099 should be issued. And these are things that you really want to make sure that you've got a good handle on. What you should understand about issuing 1099s is whoever does it kind of gets on the radar. You're on the radar, right? Because now you are reporting and the IRS can see, right, what is happening. We've seen a lot of companies that have transitioned from W-2 to 1099 or the other way around. And because of a significant impact, right, of, oh, well, we saw all this revenue before and now it's all gone, right? We don't see the revenue anymore from the W-2 side because they've converted to, well, they don't know why, right? The IRS doesn't know why. It just looks kind of like the business might have disappeared. That can trigger an audit, right? When there's a material change in the revenue, the taxes that are being paid to the IRS, that can trigger an audit, right? So determining these issues on the front end, very important, right? Figuring out what to do. Okay, so 1099K, and this is really where companies like Ally come in, and I think from what Scott said, the company, right, that works with registries, right? Ally, from my understanding, issues the 10 or will be issuing these 1099Ks. So I want to talk about some changes in the law as they pertain to 1099Ks. It used to be, right, that the 1099K, which is applicable only to payors, right? When there's a electronic payment that is collected and paid out, those merchants, think about credit card companies, think about payroll companies, right? Would, you know, eBay, right? If there were a significant number of transactions at a significant rate, I think it's 200 transactions. Actually, it's on the next slide, so we'll just to make sure I've got that right. I think it's 200 transactions and $20,000 were the old rules about. That's when a 1099K would be triggered. So only when there's significant transactions. Yes, 20,200 transactions. The new standard that's going to be effective now is $600 and just one transaction, right? That's very, very significant. These are for the 1099Ks that have to be issued in 23. There is an effort to oppose this law because the idea is that it's going to really, really create havoc and backlog, and you're going to have babysitters, you're going to have, you know, lawn service guys, kids, you know, they're cutting lawns, getting 1099Ks for, you know, a little bit of summer work and not having any clue what to do with them. So there's several organizations, I think it's 70 businesses that have opposed this, that have asked for reform. But as of right now, there's nothing that's happened. There are penalties for not issuing the 1099s. Those can range from several $100s to up to $1,000, depending on where you are, what jurisdiction you're in. So that's a significant issue, and one that it does seem that Ally has resolved, in the sense that they'll be sending the 1099Ks without the registry name on it, which is great, without the client name on it, which is great, and in compliance with these new rules. So if you are a customer, good for you. If you're not, think about it. All right, let's jump now into audits. You probably have seen all the news about all the new tax auditors that are being added to the IRS. Maybe that's a result of the 1099K issues or something else, but we've seen a big uptick in audits, and I think that's going to continue around registries and virtual marketplace type models. And so one thing that I want to make sure everybody's aware of is the defenses under Section 530. These are the safe harbors, and 3506 that apply to this kind of model, right? And we'll start with 530, which basically is a rule. And when I say a safe harbor, what this means is if 530 applies, if it applies to your organization, you are now outside of that 20-factor test. We're not going to go to that subjective 20-factor test or the common law test. We're going to look at this bright line test of section 530. 3506 works the same way. Okay, so what it means now is that these are the standards, right? Substantive consistency, meaning that the worker has always been treated as an independent contractor, right? So remember we talked about sometimes issuing W-2s, sometimes issuing 1099s. That creates a problem for substantive consistency. We want to be able to show that this model is an independent contractor model, and we've always treated the workers as independent contractors. Reporting consistency, right? That we have filed, not only have we treated them as independent contractors, we've filed the correct tax forms, right? Whether that's individually as an organization or through a company like Ally, we have treated them that way, and our tax obligations and tax forms show that. And then finally, that there is a reasonable basis for treating them as independent contractors, and that's where we'll get into the model itself, right, and things like the FAB, and that's where it can be very helpful, right, when we think about Florida law or California law with the domestic referral agencies, right, that allow you to use independent contractors. We can demonstrate that as an industry, this is a model in the industry that the Department of Labor has endorsed when it's correct, right, when it's run the right way, and the IRS has traditionally allowed that 530 safe harbor to apply. It's been harder. We do a lot of these kind of audits here. It's been harder lately, where we've had to fight more on 530 than we have in the past. But it's still a very, very viable safe harbor for federal tax law. You've got to look and see, is there equivalent in your state for state law? But very important that you understand. And you've got to also make sure that you have a way of establishing that the reasonable basis test, right? When you think about your tax laws, right, and your tax classifications. So what could constitute a reasonable basis? Court order, right? A prior ruling by the IRS once we've got 530 applied to an organization, a specific organization. They're normally golden for any future IRS audit, right? And oftentimes we can avoid the next audit by saying, hey, you guys have already looked at this for a different tax year, and you concluded as follows. That shouldn't change now. And normally they will bounce off you and leave you alone. Advice memorandum, private letter ruling, prior audit where the IRS determined that the model was proper, right? And then the recognized practice in the industry, right? That's another great one for this model, like we were talking about. So things like, the prior conduct of the government in treating registry models as independent contractor, a viable independent contractor model. Okay, so let's turn to 3506 for a moment, right? Now this one is a little different, and not everybody knows about this. It's different than 530. What matters here, right, is who is actually issuing the payment, right? And the term, you see the term sitter here. Caregivers are considered that under the way a sitter is defined: individuals who furnish personal attendance, companionship, or household care services, right? And they can be treated, if they're getting 1099s paid on an hourly basis, they can be treated as tax exempt from that 20-factor test, right? The 20-factor test will not apply if 3506 does apply, similar to 530. And one of the real questions here is who is paying, right? So let's just take a registry example, right? You see what's underlined here. If the person does not pay or receive the salary or wages of the sitters and is compensated by the sitters of the person to employ them on a fee basis. So if you've got a third party, an independent third party that is paying the caregivers, right? And the registry is not actually touching the money and issuing the pay, that is very helpful in establishing the application of 3506 and staying away from that 20-factor common law test under the IRS, under federal law. Okay, one more thing I want to make sure you're all aware of. This comes up from time to time. We've utilized this voluntary classification settlement program in the past. This has happened when, I'll give you an example, when we're doing a transaction on behalf of a registry or a consumer model, and we're representing the buyer, whichever side, and we find that there's a tax liability or a risk, right? And let's say it's a W-2 agency or W-2 provider that's buying a registry. That's happening more and more these days, where there are the W-2 agency model looking at registries and purchasing registries and then converting the registry to a W-2 model. So if we have found that, oh man, this registry really didn't do it by the book, they weren't issuing the right forms, they had W-2s and 1099s going out to the same type of caregiver. So we think there's a big tax liability. Rather than allowing that to kill the deal, what we will sometimes do is use this voluntary classification settlement program where you effectively are coming clean to the IRS and saying, hey, we think that there's a misclassification. You didn't have to find it. We're coming to you. And now you're paying 10% of the tax liability. It's a really nice program, but you've also got to be willing to reclassify, right? So if what we're saying is they're misclassified, we're going to reclassify, right? And you can't be subject to a tax audit already, right? It doesn't work after they come at you and then we say, oh, no, we're coming to you, right? It doesn't work that way, but that's a good program to understand, right? So to be eligible, the business has to have consistently treated the workers, to be reclassified as independent contractors or other non-employees, including having filed all the required 1099s in the previous 3 years, right? So you're not off the radar. You were, you were treating them as independent contractors, and now you're willing to reclassify, right? And then you can't be under IRS or DOL investigation when you go to do it. Okay, so I know it looks like there's maybe a couple Q&As that are coming in. We'll deal with those at the end here. Let's switch over now from potential tax liabilities to wage hour, FLSA, right? The Fair Labor Standards Act is the act that requires payment of overtime after 40 hours of work to the extent a worker is a actual W-2 employee rather than an independent contractor. In this world, the registry world, the consumer-directed world, in the past, there were live-in and companionship exemptions that applied to third-party agencies, so the Department of Labor wasn't particularly interested in investigating registries, right, and investigating these models, because even if they weren't properly classified as independent contractors, the DOL wouldn't be entitled to get overtime for them because they would have been exempt from overtime under those exemptions. When those exemptions were modified and eliminated in most cases, right, for the third party employer or the agencies, now all of a sudden the DOL became very interested in the registry model. Why? Because now if the DOL can establish that the workers who are being placed by the registry are not actual independent contractors but employees, there is an overtime obligation, there is a minimum wage obligation under the FLSA, right? So they use the FLSA and the Department of Labor, they use something called an economic realities test, which is somewhat like the 20-factor test in that they focus on control, how much control does the business exercise over the worker, but they also focus on economic dependence more, right? How dependent is that worker on the organization? That's where the hours come in and the length of relationship come in, right? These are the factors in the economic realities test that you see here. I'm not going to read them all to you because they're very similar, right? Profit and loss, right? One I'll mention is there a requirement that the service rendered requires special skill? That one hurts the registry, the personal care model, because a lot of times there's not a special skill, right? It's something that many people can do from a skill perspective, maybe not from a, the mentality that you have to be a caregiver, I think is really unique and special, but that's not what we're talking about. We're talking about how much skill is necessary to actually do the work. So the economic realities test, this one was being used. It's extremely subjective, even more subjective than the 20-factor test. And the Department of Labor was using the economic realities test to find misclassification in just about every setting for a while there under the Obama administration, right? Big focus under the Obama administration on reclassifying registries into W-2 models, right? We saw a lot of that. That continues. There's been a lot of DOL investigations, but now that there's the FAB, which stands for Field Assistance Bulletin, this was something that was issued in 2018 as a result of some lobbying, some efforts done where registries and consumer-directed models work together to try to get more clarity on what is the standard that needs to be followed for a model like that, right, to be considered a viable independent contractor model. We knew because in the preamble of the changes to those exemptions we talked about, the DOL talked about a registry and such a thing as a viable registry, a viable independent contractor model. So it was very confusing that nobody could pass their test, right? So the FAB now provides 10 factors, taking the economic realities test, taking the same standard, but now using the economic realities test and applying it directly to these consumer-directed models, right? And really getting into great detail as to what is the difference between an employee and a contractor with respect to the consumer-directed model in home care. So it is the most valuable guidance that the consumer-directed model has to date, right? Background checks, reference checks, hiring and firing, right? These are the what you're looking at are the standards, right? The factors that apply, okay? And rather than go through each of the factors, right, what we're going to talk about a little bit are some of the activities we see that lead or cause the Department of Labor to say that the FAB wasn't followed, that the economic realities test was not passed, i.e. the worker is really an employee, right? How much instruction is there? Is the agency, the registry, the model, right, the matchmaker, the one that's providing instruction about care, right, rather than the client? Does the registry create a care plan, right, and work with the client to determine what the client's needs are, right, where the agency or the registry is determining what that care assessment should be, rather than the client telling the agency, right? As the agency, and when I'm saying agency, I keep saying agency or registry, I'm talking about this model, right? The consumer-directed model. Do they monitor and manage the caregiver? Are there assessments? Are we going to the home and looking to see, is the caregiver doing their job well, right? If that's the case, that's more likely to be an employment model than a 1099 model, right? Is there these check-ins? Are the registries trying to prevent caregivers through restrictive covenants from working for other businesses? That's a huge no-no. Non-compete, non-solicit, where we're we're saying to the caregiver, you cannot work for our competitors, right? Or, we don't want you engaged in certain activities where we are restricting the caregiver that aren't related to protecting the business. It's different than saying you can't steal our client list, right? And share our trade secrets with other businesses. That's okay. But as soon as we're restricting their ability to work elsewhere, that's when you run into a problem. To caregivers, how much do the caregivers have to interact with the agency, right? About canceling, being late, right? Again, that's an indicator of supervision, as opposed to that interaction being directly with the client, right? And who is setting up the substitute caregiver, right? Is it the registry saying, what, this caregiver isn't working out for you? You haven't told me to go get a new one. We're going to go find one for you. We're going to be subjective in determining which caregiver we're going to send to you, as opposed to opening it up to multiple caregivers and letting the client decide for themselves, right? Is it consumer directed or agency directed, right? Is the agency in control, or is the consumer, the client, in control, right? And does the caregiver have a say in all of this? That's basically the analysis. All right, so quickly, let me just cover this. A couple of these factors: hiring and firing, right? The client is the one that needs to be responsible for terminating the relationship with the caregiver. That should not be the registry. The registry's role is to make the introduction, ideally to multiple potential caregivers, and letting the client decide. Who is setting the rate of pay? Is the caregiver telling us what they want to receive, and the client telling us what they want to pay, and we are serving as a liaison between the two, or they're negotiating that directly? Or are we saying, hey, we can pay you X dollars an hour, caregiver, and our charge client is X dollars an hour? That creates a problem. That means now, because we are setting the rate of pay, that the caregiver is not responsible, right, for their own profit and loss. We are, because we're telling them what they're going to get paid, right? That's an agency, a W-2 agency model, not a consumer directed model. There should be some negotiation there, right? Some documentation that the caregiver is setting their rate and telling you what rate they will work for, rather than the agency. The pay structure is a big deal to the Department of Labor. And I don't have time to go through all these in great detail, but I will say that what the DOL really wants, and it's not how registries work, this is one of our biggest pain points. They don't want the registry fee to be tied to the hours, right, that the caregiver works. They want there to be kind of a one-time placement fee, an expiring fee that's based on the agency's cost, right? Their cost plus their margin, right, for making the placement, rather than the length of service or how much the caregiver is getting paid. That's not normally how registries work. Just understand that that is a pain point, and there are some ways of restructuring this that are helpful, but not always what registries want to do, because you end up making a little less money sometimes. Okay, so what is the switching now to the legislative updates? What's going on with Biden, and in general, what we're seeing, and you've seen this across a variety of areas. There's more protection for workers, harder to utilize an independent contractor model, right, and more targeted audits towards the home care businesses. And we know that independent contracting has been a major issue. You see this quote here. It's been a major issue for this administration, just like it was for the Obama administration. We see withdrawing of opinion letters, any opinion letter that was utilizing the modified independent contractor rules that Trump tried to put in place, that were repealed. So were the opinion letters. There was an opinion letter that was very helpful for virtual marketplaces that was also repealed. The FAB, though, was not repealed, and there is no plan as far as what I understand. I talked to the solicitors of the DOL all the time, and those who are responsible for overseeing the home care investigations. There's a whole home care committee that sits in DC that reviews any determination recommended by one of the investigators to make sure that they're being consistent. And there is no plan to withdraw the FAB because the FAB relies on the economic realities test that is in place today, and not the one that Trump was trying to put in place that would make it a little easier to utilize independent contracting. So we are actively dealing with the DOL across many jurisdictions focused on this kind of model. So it's really important to be diligent. Just like the IRS, the DOL has added or is in the process of adding 100 new investigators, and they are very focused on your model. We see registries get in big trouble with the DOL all the time, right? It is very important if you have a DOL investigation to hire counsel, hire qualified legal counsel right away. Do not wait. Do not try to do it later. I had a recent registry case where the registry contacted us after the DOL made a determination that they owed the DOL $500,000, $500,000. It's a lot too late for me to be able to help in any meaningful way at that time. You know, we're kind of cutting around the edges here and trying to help, but it's getting in early, and it's not just about the monetary damages. That's what I want everyone to understand, is the DOL will often ask you to consent to something that makes it not possible, right? And you don't even realize it. Maybe the back wages are not all that high, but they're asking you to comply with something that it's not going to be possible for you to do under your model. And you've just signed on to something that you don't realize is going to cause you now to have to reclassify these workers as W-2. And I've seen that happen several times where the back wage has just been a couple $1,000s, but then the DOL comes back and says, hey, you agreed to comply. Compliance to us meant reclassifying, and you didn't do that. So guess what? You owe back wages again, and now civil money penalties and liquidated damages and all the rest of it. And that actually is a tactic that the DOL will sometimes use. Solicitors have admitted that they'll come in and try to get a little grain, right? Just a little money to get that agreement in place, especially with the larger independent contractor models, right? Of let's get a precedent and get them to acknowledge that they have to be compliant. Then we'll come back and hit them really hard the second time. That does happen. So you need to make sure that your staff, your W-2 staff, right, that work in the office, that they know to immediately contact you, and for you to contact outside counsel if the DOL comes, and to tell the DOL this isn't a good time. The DOL will come. When they come, they are going to push you hard to provide them with a lot of documentation, a lot of information right away. They're not going to give you any time to do it. They might want to actually start having conversations with you and your organization right then and there. You tell them it's not a good time, it's an interruption of your business, and you'll get back to them. Then we will come in, or whoever your counsel is, extend the time, limit what we're producing, and get this off on the right track. Also understand that the DOL, when they investigate, they are looking at everything. They're going to look at your website. They're going to look at your payroll. They're going to look at the exempt status of your office staff. They are looking at everything. So here's just a couple of tips where we see on websites and advertisements, brochures, right? Marketing, the registry services are often, framed in such a way that they're not particularly helpful. Here's just a couple of tips. We do a lot of this where we're looking at the site, right, which is what the DOL is going to look at. The first thing they're going to look at. And if we're advertising care, hey, we provide the best care. We have the best caregivers, right? And not making it clear that it's a referral model, right? Explaining what the model is, that hurts us, right? So you've got to be careful how you are advertising the work that you do. Let me jump quickly into compliance. And again, I know I'm moving fast, but we had a lot that we wanted to cover with you, and I do want to get to questions to the extent that you've got some. So what are the missteps that we often see? Caregivers not actually negotiating rates or determining, saying what their range of rates are that they want, not marketing their own services, right? Registries being involved in the care plan, right, and setting up their own care plan and not having the right paperwork in place, where it looks like the registry is the one that's setting the care plan, right, and providing a lot of care related materials to either clients or caregivers. Hey, we've got this program, that program, all these care programs, right? We can do this for you. We're great with dementia, right? As opposed to our caregivers have these services. Registries being overly involved in scheduling, the website, like we just talked about, not being clear what the model is, right? And making it seem as though the registry is providing care on behalf of the client. The registry being involved in substitutions, right? And doing things without the client asking those to be done, using non-compete agreements, like we talked about, those restrictive covenant agreements. The caregivers are interviewed by the DOL all the time. That will happen every time. And the caregivers are normally the worst source or the best source of evidence for the DOL in determining misclassification, if they believe their employees, if they see the registry as their employer. So having consistent check-ins with caregivers to make sure that they understand the model and that they're in charge, really important, very important. Treating caregivers the same. Sometimes people will say, look, I want to move from an agency to a registry, but I don't actually change the model. I just change the way it looks. Wolf in sheep's clothing kind of thing. Advance payments to caregivers, there are ways around that, but if the caregiver doesn't bear the risk of a client not paying, the registry does, that's an issue, right? And using agency type materials in a registry, see that all the time. Things that really are suitable for a registry, an agency, but not a 1099 model, big problem. Arbitration, I just want to touch on this briefly. It's the most critical thing you can have for purposes of individual lawsuits, which are the biggest issue, right? That is the bet the company issue for a registry, is a class action lawsuit brought on behalf of an individual. That is what these plaintiffs' lawyers are looking for. An arbitration agreement with a class action waiver can help with that, but you also need to make sure that you're using the right kind of arbitration agreement that applies to independent contractors. Don't use an agreement that applies to W-2, right? Because the laws that apply to W-2 are not the same as independent contractors. So you need to have the right type of agreement in place. We do a lot of work with registries and helping registries to get compliant, to review their client service agreements, contractor agreements, live-in. There's a way to structure live-in where you are building overtime into the rate that you're paying, which I highly, highly recommend, because live-ins are such a vulnerable position to be treated as misclassified because of the number of hours. A lot that we can do to help you, but do understand that having the right materials in place, this is really a consultation, right? Where we understand your business, we spend time really kind of unpacking it, identifying where you have vulnerability on your site, on your website, in your marketing, in your practices, and then framing the paperwork around the model that you're actually running, right? First, tweaking the model, fixing the things that are needle movers for misclassification, right? But if you just take materials and you put them in place and don't change anything, it isn't going to help you, right? You're still going to run into misclassification. It actually might hurt you because the materials say the right thing, but you're not actually doing what you're supposed to do or what the materials say that you're doing. So it's not a panacea to fix things. Now, one more thing I want to mention, when we talked about the FAB, right, and going through a process like this, right, there are defenses to the FLSA, good faith defenses, One is if you actually believe that you took action in good faith, you had good grounds for believing that you were doing the right thing, but it turned out that, you know, a decision maker didn't agree, right? And I think that that is very, very possible that you can get a good faith defense. We get them all the time, almost 100% of the time. I can't think of a time where we have had liquidated damages or double damages applied to a registry. I have seen it happen, but the idea is, look, we believe we had the right classification as an independent contractor, and we went through a process of reviewing the FAB, making changes, doing the type of things that should have resulted, in our mind, in this model being a solid independent contractor model. You don't agree, and you're saying that we owe back wages. It should be limited to only back wages, right? And no liquidated or double damages. So you cut your exposure in half, and you also eliminate the third year of damages, right? It goes from 3 to 2. That is very, very doable. So that's a significant factor in how you handle your compliance and the types of things you do, and not just doing them, but actually documenting what you've done so we can then demonstrate it to the Department of Labor. Now, if you have taken actions in conformity with an actual regulation, and the reason I'm mentioning this is, or you in reliance on an agency regulation, right, or an opinion letter from the Department of Labor, that is a complete defense to liability. The FAB counts as, it's like an opinion letter. It is guidance from the Department of Labor. So if you know about the FAB and you're following the FAB, now you will actually, you know, if you're found to be in compliance, that's a complete defense, right? Because we relied on what the DOL told us to do. That's why the FAB is so important. So when we send out the recording, we are going to send you that FAB. So you all have it, take it, print it, use it. Let's, Derek, if we can launch this poll here. There is a poll here. If you want our help, let me know and we'll reach out to you. We are not in the business of chasing anyone around. We're not going to bother you. If you feel like you're compliant, you don't have issues, you don't want to address this now, don't respond. But if you do, then reach out and, you know, reach out on this poll, and that will cause us to ping you and get the process started, or at least talk to you about it. So again, you're not going to hurt my feelings by saying no, don't need you. But if you do, we want to be here for you. I love this industry, care a lot about this industry, and I want to help any business that I can. So I think that launched. Is there anything else I need to do? If not, then we can turn to any questions that we have. Oh, good. I see now that we did put the FAB on the chat feature, so hopefully you all do have access to it. Scott, were there any questions? It looks like some questions were answered.
Yeah. So let me go ahead and just go through a few of these. Laura submitted a question that said, can you please explain further why it's problematic to staff for a facility? Is it because it's in a facility and not in the home?
That is generally the reason, right? Is that, so I'll try to break this down a little bit. And I'm happy to stay on a little bit extra. Folks have to go, it's okay, but I want to make sure that we get your questions answered. So the issue with the facility, right, is before all the registry investigations by the DOL was looking at general staffing, a staffing model versus a headhunting model, right? A placement model. That's also, by the way, why there's such an issue about how the registry catches their fee. How do they get their fee for their services? And the staffing model, not counting this industry, just general staffing, used to be a lot of 1099s, and the DOL came in and said, no, there's a consistent schedules, right? You continue to make money off of who you're staffing, right, off those individuals. That's a W-2 model. So when the DOL sees facility staffing, they look at that more like the overarching sort of staffing rules, and we'll almost always find misclassification there. Part of the reason for that as well is that the hours are generally more consistent, right? We're saying that these are 1099, right? But we're saying that they have a set schedule from X time to X time, and we can replace them with other people. And, that's the schedule Monday through Friday. But generally the issue with staffing facilities is that it falls under that same sort of analysis the DOL has traditionally done around a general staffing business.
All right, great response. I'll ask, the next question came in from an anonymous attendee. Is the client required to provide a 1099, or will a printout from Ally to the independent contractor of payments received from the previous year suffice? I'm happy to actually answer that. Just from my experience, Ally will be issuing the 1099K to the caregiver, to the independent contractor. As Angelo defined in the previous screen with the 2022 rules going forward, any amounts received by the caregiver of $600 or more, regardless of the number of transactions, qualifies them in a position to receive that 1099K. So Ally will issue that digitally automatically at the end of the year. They'll be notified and have access to receive that 1099K. It will have two names on it. One will be Ally as the quote filer, and the other will be the caregiver as the payee. It will in no way name the registry, leaving you out of that in all circumstances, and it will no way be including the care recipient or the payor, if you will, the initiator of that payment as well. So that takes a lot of burden off of both parties, registry and the care recipient traditionally, at least from a historical perspective, and at least from the standpoint of the registry, know that you're meeting full compliance requirements. Anything you want to add to that, Angelo? Are you good there?
No, I think that's great.
Okay. Ray submitted a question saying, does the PCA certification help with this too? So I think thinking back on that, I think they're referencing the alignment, maybe being a PCA member. Does that help maybe shine the light that they are a registry as opposed to an agency from the perspective of employment?
Yeah, I think it does. I think anything that you're doing, whether it's PCA, working with us, anything, doing it yourself, right? And if you are actually taking the FAB and applying it to your organization, that is going to be helpful in establishing that you are making efforts to be compliant. Hopefully you are compliant, but like I said, there are some defenses that apply, the good faith defenses in this model that wouldn't otherwise exist for traditional agencies.
We've got a few more. We got a bunch pouring in here.
Yeah, I see that.
So,
bring them on.
Yeah. So Jessica asks a really good technical question. If you're saying that caregivers are not to be given, quote, care plans for the clients, how are they to get any information about the client to decide if they want to take the job or not? Also, the Pennsylvania Department of Health requires an assessment to be done by the registry. Is that something you're saying we should be doing or performing with limitations?
Yeah, it's a great question, and this is going to come up a lot. And I saw another question, so I think we can kill two birds with one stone about, well, what about long-term care insurance, right? That requires you to submit, the care plan. So one of the great things that the FAB does is it says, look, if what you're doing, whether it's background checks, right? If you're doing in Florida, level 2 screen, and that's required by the state, right? If you are paying a rate that is dictated by a Medicaid waiver program, and they say that this, these are the hours, or this is the care plan, and you're following what another third party is telling you to do, that's not indicia of employment. So that's really helpful when you're talking about the Pennsylvania Department of Health or anyone else, the long-term care. The key, though, is that you make that clear, right? So I'm not telling you that you can't do any kind of assessment. How you do the assessment, the why behind what you're doing the assessment for, the why behind why we're asking a caregiver, if they fulfilled the plan of care, right? Did they do it? the things that they're supposed to do. This is for reporting purposes. This is so we can, if that's the seat that you sit in, that you're submitting this to a third party for payment, we're explaining that. The state requires this, right? In Florida, that we made it clear in the law, right, that to the extent we are keeping records on behalf of the client, right, we're serving as a repository because we're required to by ACA, right, not because we're monitoring and reviewing things. So there's evidence that you can basically create in your paperwork, right, as to why you're doing things. And if you're getting that from a third party and it says things in it like employee and this and that, right, which happens a lot when we're taking materials from a third party that we've got to utilize, like a payor, we want to have something on top of that that explains what it is, where we got it, and what we're doing, right? And that can be done through acknowledgments, that can be done through checklists. There's a lot of ways of doing it, but what happens too often in this business is we don't document why we are doing what we're doing, and so the DOL can come in and make any conclusion. So it's the same thing with the rates, right? You can, well, how are we supposed to communicate to the client what it is that the caregiver is willing to pay when we're the ones that are communicating, right? You find out in advance from the caregiver as part of your registration process, what are the rates you're looking for? Give me a range. Now we can serve as a liaison on behalf of that caregiver and on behalf of the client and say, hey, look, in this market, the rates are about like this. So if you really want a quality caregiver, this is what you should offer. That's different than saying, hey, our services are going to cost you X dollars and we're going to pay the caregivers Y dollars, right? So it's the way that you frame all this that's so significant, because remember, the Department of Labor is going to come in and they're going to analyze everything that you do, everything that you touch, what the caregivers have received. The only thing that the DOL doesn't touch are your clients. They're not going to go and ask the clients what you said to them, but they're going to look at every piece of paper you utilize. So as a registry model, less is better. You don't want to have too much stuff, right? Just what you absolutely need, and then it needs to say the right thing.
So in that thread, this is really a good question. Sandra poses a question saying, does it help to classify someone as an independent contractor if we pay their LLC instead of the contractor?
Excellent question. And I think the answer to that question is it depends on why they have an LLC, right? Do they have an LLC because they believe that they are marketing themselves, right? Or do they have an LLC because you require them to? And this has come up time and time again with the Department of Labor, where they say, look, you are showing the independent contractor how to create a LLC, right? You're setting them up, right? You're basically, that's just a subterfuge, right? As opposed to, and now in today's world, a lot of people will they'll come up and they will, already have their LLC because they've done something with another registry or whatever. That's good. But if you have a program where you require it, that doesn't move the needle very much. If though they truly are marketing themselves and they, and they utilize their LLC with multiple businesses, that is definitely helpful. So it sort of depends on the circumstances, but we have seen the DOL in recent years disregard these sort of LLC programs where the business requires and helps the caregiver to set up their LLC.
We'll see if we can get through just a few more. I appreciate everyone staying over on this with us. These questions, I think, are vitally important to just daily experiences. We had an anonymous attendee submit a question. With a dual model, would that help if you could say they were offered whether or not they wanted to be an employee versus an independent contractor? And if they're able to choose the one they wanted, are you saying we need to operate two different companies?
Yeah, great question. I'm working with a company right now that they run a dual model, but they run it within the same business. So it's a real problem for us. And that's exactly what I'm asking them to do, is split your business in two and have a agency side, a W-2 agency side, and a 1099. So they're licensed as a registry and independently as an agency. So if you're going to have a dual model, it should be two different companies. And what you need to do is keep them separate. You can have some of the same W-2 staff that's running the businesses, but those businesses need to be separated for purposes of independent contractor and W-2 caregivers. And if they're switching back and forth, if sometimes I'm W-2 over here at this company and then I switch over to 1099, then you're just considered a joint employer and you're not helping yourself. But if you can keep those businesses separated and demonstrate a true difference, right? That, hey, this is what we do on the agency side. These are the materials we use on the agency side. You see, there's a handbook on the agency side. There's a dress code. There are badges, right? We tell them what their rate is and where they're going to go. On the registry side, we don't have those things. We've got, these materials and they get to decide, right? And when somebody comes to us, a worker, we can give them the option. So they decide for themselves which model they want to work at, right? That is helpful. That's when we can demonstrate that. That's actually pretty helpful to demonstrate all the differences, that these are two different models, right? And the caregivers self-select in. The other question that I'll answer that I know somebody's asking is, well, what about, if a caregiver doesn't want to do the agency work anymore and they want to become a contractor? What I typically say, or vice versa, give them one opportunity to switch, but they can't keep switching back and forth, right? If somebody they want a different, hey, I've got a sick kid, I need to have a more flexible schedule. I want to, I don't want to do all this. You're telling me where to go and have to work 40 hours. I'd like to be on the registry side. All right, we're going to terminate your employment over here. You're going to get you set up with our paperwork on the registry side, and there's no moving back, right? Can't keep going back and forth. So well documented that one move is okay.
All right, we'll try for just two more questions and kind of wrap it up. Anything that we don't answer today, we will definitely follow up with you and provide written responses to you. So I don't want you to feel your questions have been missed completely, but just for the sake of time. Question with regards to overtime. Sandra writes, does it help to avoid overtime issues if the contractor works over 40 hours with several clients, no more than 40 hours for each specific one, rather than working more than 40 hours for a single client?
Great question, Sandra. I'm glad you bring this up because this is something that I think is a big misnomer for the consumer-directed model. If you have a caregiver that's working multiple hours for multiple clients and you are deemed the employer by the Department of Labor, then those hours are all aggregated. You're seen as the employer, just like in a staffing model, right, or a traditional agency model where it doesn't matter what client you're working for, as long as it's the client of the agency, it's your hours working for the agency, right? You're the employer now and not the client, or it's a co-employment situation or joint employment situation. So that's where registries sometimes run into problems. Like, well, we don't have anybody working more than 40 hours, right, for one client. That time gets aggregated. So you got to be really careful about that. And then it becomes difficult because some of the registry models, because of the target on the back, right, with the DOL, they will incorporate overtime into the model, right? And say, client, if you want to work with this caregiver more than 40 hours, then you've got to pay the caregiver overtime as well, right? Or the caregiver is probably not going to work with you. There's still a way of doing that where the caregiver is making the election, the client's making the election. It's not the registry that's requiring it. But I think that's a good thing to consider given the environment that we're in. But that doesn't really work. It's very difficult if I'm working as a caregiver 20 hours for one client and 30 hours for another client in the same work week. Who's paying the overtime in that situation, right? And what some of the registries are doing is they're going to client 2 that's looking for the 30 hours and say, if you want that particular caregiver, they already have another assignment. So there would be 10 hours of overtime there for you to pay because they've already accepted another client. But we can also find one for you that isn't in that situation that wouldn't have an overtime requirement, right? So there are ways to deal with it, but that becomes a little harder. But the idea of working for multiple clients really doesn't help you. It is how you are set up as a business and how you run the business that's going to matter.
Great response. A lot of technicalities on that, so people need to be thinking about that. Does the DOL have the same point of view on hospice home health staffing as the facility due to the fact that there's a set schedule?
Yes. Yeah. So whether it's home health now, home health hospice, there are other things that can be done, right? If we're talking about an RN, there is a way to treat an RN still under the professional exemption as exempt, right? As exempt from overtime. So if they're a contractor, right, and that's the professional exemption, right, on either fee basis, right? There's ways of working with that individual to make them exempt, such that if they were misclassified, there would be no overtime obligation anyway. Same thing with a physical therapist under federal law, right? And in most states, right? RNs that won't work in California. So we want to really look at that. But yes, to answer the question, if you are staffing a facility, whether it's personal care or home health, hospice, and you're paying that individual hourly, right? They're getting hourly pay, or the facility's paying hourly. That's still going to be seen as a real problem on the classification side for the DOL.
All right. Someone wrote back in saying, going back to the 1099, I know last year the 1099 was only issued if the client provided a social security number. Has that changed? Ally's position is for us to be able to issue the 1099K, we will require either a social security number or a tax identification number, an EIN. Ally's system has a plan of care. If the plan of care is completed by the client or the client's family and or directed by the client to the referral, would that be considered a third party?
I think that's to me. So yeah, if the client is filling out the plan of care, right? Because it's like what the other person asked, right? The client's going to have to say what it is that they need, what service they need, right? For the agency registry model, right? To identify the right resource for them, right? What their hours are, what their needs are. So that's very helpful to demonstrate that it is a consumer directed model when the client is doing it, right? Where we run into a problem as in the registry world is when we have these care coordinators, which they shouldn't be called that, right? Or schedulers, they shouldn't be called that, who are taking information and they're putting in a care plan that belongs to the agency, right? And they're directing the show, right? They're the ones that are saying, we prescribe this for you. We think that you need this. So how you frame that information, we are collecting from you, client, the information that we need from you to service the care that you're asking us for, right? To make sure that we've got the right resource to provide that care. That is the way to frame it. That is, I'm not sure about third party, what you mean by third party, but yeah, I think it's probably related to my point that it's not the registry, but somebody else that's directing the care and the plan of care. So if that's what you mean by that, I agree that that does move the needle.
Actually, there's a good question for you, Angelo. Are we able to purchase the appropriate paperwork regarding the state-specific requirements? Does your website, Polsinelli website, have a resource page that they're able to see which requirements by state?
We actually have a subscription service that does that, takes basically every independent contractor standard and the licensing requirements in every state that our clients subscribe to, right? We work with a lot of the virtual marketplaces, so they're trying to keep up to date on, where can they operate, where can they not operate, what do they need to do to operate, and then, is it a problematic state or not, right? And we color code them red, yellow, and green. So that is something that we do. And yeah, we work with, depending on where you are, what state you're in, we work with companies all the time. When you're saying appropriate paperwork, yes, but what we do is take your material, look at what you've got, understand your model, help you tweak that model, right? Of, hey, you really shouldn't do this, or here are some alternatives. And there's normally many alternatives, right? Like the prepayment you can deal with prepayment in a lot of different ways. You can say, we're going to put a security deposit down and make you pay 2 weeks up front, client, so that we don't run into an arrears problem where we're paying the caregiver and we're assuming the risk. You can have in your paperwork something that says, if we pay you and the client doesn't pay us, we can claw it back, right? There's different things that can be done. So there are normally several options, right, to solve the problems that we traditionally see. So we kind of work with you through your material to determine your model and what your choices are, and then prepare the materials that comply with those choices.
All right, great. So from my perspective, that's all I see for questions. I really genuinely appreciate everyone's interest. For those that have stayed over well past the top of the hour, thank you for that. Thank you for all the questions that have come in. We continue to be excited about our relationship with Angelo and Polsinelli. We look forward to continuing more webinars like this on a broader array of subjects, especially as we come into the new year. It's going to be an interesting next 30 days to see how that formulates going into the new year. With the midterms coming up. We will continue to review any questions that didn't get answered, maybe a couple more still popping in there, but for the sake of time, we'll go ahead and put a wrap on this. Do expect an email from Ally, and I'm sure Polsinelli as well. We will provide a link for you guys to access this so you can watch it on demand, so to speak. And if you have any other further questions, we encourage you to reach out to Ally directly, myself, or any of my team members. If it's legal issues, obviously reach out to Angelo and his team, and we'll look forward to seeing you on the next one. Angelo, thank you for such a great job today.
Wonderful. Thank you all. I appreciate the time and the opportunity, and Scott and team, thank you so much for putting this on. This stuff is so valuable to just share kind of how things look and what to do, and wouldn't be possible without you. So thank you.
Our pleasure. Have a great week, everyone.